Good afternoon, everyone, and welcome to the first in a new series with our property team. We're calling it the Property Roundup, and the teams will be talking about current hot topics in the property marketplace. We have some new members of the team today, and I'm going to hand over to Michael Shapiro shortly, and he will do the introductions. We are having a few issues with Eileen's vision, which I'll be sorting out in the background whilst Michael is talking, so any strange noises, please excuse them. As always, we do have some pre-submitted questions. Thank you for those. And those of you that have anything that pops into your head and would like to ask the team whilst we're talking, please use the Q&A or the chat toolbox or chat facility in the toolbox at the bottom of your screen. So without any further ado, Michael, I'll hand over to you and I'll see if I can release Eileen from the box.
Yeah, hello everyone. For those of you who don't know me, I'm Michael Shapiro. I'm the partner who heads up the property team at Silver Shemmings Ash. So as Julie said, welcome to the first of our property panel sessions for 2021, where we're going to discuss the legal issues that we have recently had raised by clients and those issues that are at the forefront of the property world and in the news. I'm delighted to welcome two new solicitors who have recently joined the property team here and volunteered to be on the panel. Abu Vali Mohammed, who you can all see, joined us at the start of last month and is helping to steer the growth of our residential property team. Abu has experience in a wide range of property areas, including residential and mixed-use development, asset management, both for landlords and tenants, and of course, acquisitions and disposals of both freehold and leasehold properties. You will have an opportunity to see Eileen once the technological problems are resolved. But meanwhile, I will introduce you to Eileen, who joined us last autumn. Eileen is an experienced dual qualified litigation solicitor in England and Ireland, with many years' experience in handling a wide range of disputes. She advises on all aspects of property litigation, both commercial and residential, including recovery of rent and service charge arrears, forfeiture, lease renewals, dilapidations claim, party wall disputes, and right to manage claims. As you would imagine, at present, she's keeping busy, both advising landlords and tenants. She has spent many years working as an in-house counsel for the largest residential freeholder in the UK. So there are a few, if any, property issues that she is not familiar with. And hopefully in a few minutes, she'll be familiar with the technological issues and she'll be able to say hello to you. So the next thing is for me to get the B word over and done with. Brexit and the ending of the transition period shouldn't really affect property work in this country. Whilst we lawyers cannot practice property work outside our own jurisdiction, which for me is England and Wales, unless we are duly qualified, which I'm not. Much of my work has a foreign element, as many of my clients are based overseas, and they are likely to either acquire space for their English operation or buy and sell investment properties. I've not really seen any lessening of that work due to Brexit. All my services are provided for the lettings, sales, or purchases for properties which are situated in England. That's the key, that the property is situated in England or England and Wales. So I don't really think much has changed for us property lawyers. However, the Brexit Free Trade Agreement excludes representation, legal advisory and legal authorization documentation and certification services supplied by legal professionals. For some reason, when the final negotiations were taking place, they rather forgot us. So I think compared to some of my friends and colleagues who are dealing with trading agreements and competition law, property work in England with an involvement of Europe, or for that matter, worldwide, should not dramatically change for either any of our clients or for your lawyers. However, things have changed in the property market generally over the last few months. Housing market transactions reached their highest level since 2006. However, overall transactions last year fell by about 11% year on year, although this should be taken in the context of the 8-week shutdown of the market and the fact that the global financial crisis in 2008 saw transactions fall by 43%. The stamp duty land tax holiday introduced last July helped fuel the boom in the housing market. And for those who want to take advantage of the stamp duty land tax holiday, where basically the stamp duty threshold has been raised to £500,000 from £125,000, have only got 2 months to do so. Despite the increase of mortgage lending, there are some analysts who predict that the end of the stamp duty holiday will signal a dampening down of the housing market. There are concerns that if the stamp duty holiday is not either extended or tapered off more gently at the end of March, then some purchases which are designed to take advantage of the holiday will not be completed by the 31st of March and effectively abandoned. This will be an ensuing loss both to professional services, because obviously we won't get our fees, to builders who will be doing the home improvements, and to retailers who will be supplying all the items to fill the house with. So this leads me on to the high street retail market. There are calls for business rates relief to be extended until the end of the calendar year rather than the financial year at the end of March. Last year, retail sales suffered the largest annual fall since records began in 2006. My own view is we can't blame this entirely on the pandemic. It was what was coming anyway. It's just the pandemic seems to have been the catalyst to really speed this up. And this week has seen the potential for more than 500 Debenhams stores to be closed following the acquisition of its online business by Boohoo, and negotiations over disposal of part of the Arcadia Group by ASOS, who by virtue of their business model are unlikely to have plans to acquire any of the stores. These are two major retailers that are likely to be acquired by digital purchasers who very simply would not want to sell in shops. Competitors have said that there will be a reordering of the retail landscape, with declining customer numbers on the high street and the shift of consumer habits towards online shopping, both trends that have been speeded up in the last 12 months by the pandemic. And today I read a survey that empty shops are at their highest for 30 years. And that was an RICS survey, which is worth taking note of. Finally, in a previous panel discussion, I talked about the downsizing of commercial offices and break notices and what follows through. But as I have seen a pre-submitted question from one of you about that, I'll leave that until the question and answer session afterwards. So now, as Eileen is still having a few problems, we'll go on to Abu, who is going to talk about cladding and conveyancing transactions. And in fact, just before Abu starts, I'll welcome Eileen, but I'll give her a few minutes to relax, and we will still hear from Abu. Thanks, Abu.
Thank you, Michael.
You're on mute, Abu.
Sorry about that. No, so with regards to cladding and property issues, so I think there's around 300,000 or more flat owners that are currently facing issues with regards to being unable to refinance their properties or being able to sell them on. So this has been ongoing since the Glenfield tragedy in June 2017. As lenders require a external wall inspection to take place, and there's certain issues that have kind of cropped up over the past 2 years, which has made this quite difficult. So I think firstly is a shortage of experts, and then secondly, those experts that do want to practice in the field are unable to get professional indemnity cover as well, as there's not that many insurers that wish to provide cover with regards to that area. So due to that shortage, and many of the sites that do get inspected, there are remedial works and so forth that are required. So this has kind of left people trapped within not being able to, most people that are in a building with cladding, they're most likely looking to upsize or relocate, and they've had changes in their personal life, and it's made it quite very difficult for them to be able to proceed. In terms of just in December last year and towards the end of November, the government did announce that buildings under 18 metres will not require a EWS1 certificate, and also those buildings that do not actually have cladding, where it's, because we did during conveyancing transactions see quite a few inquiries asking us about the certificate, even when it was clearly clear that the building was a brick building, and you'd still have to deal with that inquiry, and it just delayed the conveyancing transaction. The only thing in with regards to the guidance that was given, it is guidance. So we're still seeing some lenders still insisting on having some proof before they proceed with an application. So they still are asking, if there isn't an EWS1 certificate available, they'll want to see a fire report to kind of acknowledge that there's no cladding on the building, and sometimes even for those buildings that are under 18 metres. So currently there's still other reforms that need to take place, and it hasn't been helped by the current pandemic as well, that we're unable to kind of, there's many people still without having the managing agents being able to have the required certificates due to delays with inspectors. And also there's quite a number of buildings that are still having waking watches attend at their properties, and this is quite a cost which the leaseholders are having to bear. I did come across an article with regards to a housing association that wasn't passing on the cost straight away to the lessees, as they were hoping to see whether they could claim it back from either the insurers or the developers, because it then brings about a litigation argument that at the time building was this building with cladding being put up, meeting the requirements for building regulation at the time and fire safety standards when it was being built, because sometimes the materials that have been used were tested, and it was quite well known at that time that they weren't really fit for standard. It might have been, sometimes it's delays in materials arriving or changes in the environment while the development's taking place. So that is something that's quite interesting, and there might be further cases in the coming years with regards to litigation. So this is something that if there is anyone that is currently experiencing, we're welcome to having inquiries and having to help them or assist them and look into. And also there is quite, those people that were looking to sell earlier on, it might be something that's possible now for them, as there's been a kind of guidance given by the government with regards to the types of buildings that require a certificate. It would be quite helpful, and I hope that in the coming year they kind of introduce a search platform similar to what we have for energy performance certificates, where you can type in the address and see if a building does have the certification, because you kind of see that there are sometimes where a seller has put a property on the market unknown to them, that it might not be something that's sellable. A buyer comes along and goes through the process and is unable to obtain a mortgage, and then there's an abortive sale or purchase transaction. So there's certainly things that the government is currently looking at, and hopefully those do come into place. So I think that's pretty much everything that I wanted to say about cladding.
Abu, thank you. And I'm sure we'll be coming back to this in the question and answer session, because it's such a topical point for discussion at the moment. So now I am pleased that you will all get the opportunity to see and hear Eileen, who is going to talk about forfeiture.
Thank you, Michael, and apologies for my tardiness. It's beyond my control. Anyway, I'm here to talk about the impact of the Coronavirus Act 2020 on landlords, both residential and commercial. I'm going to start with the commercial landlords. So pursuant to Section 82 and 83 of the Act, there was a moratorium placed on forfeiture and rights of re-entry for commercial landlords for non-payment of rent. It didn't apply to other rights of forfeiture for anything in relation to non-payment of rent, but obviously under this there was a moratorium, so there was no action allowed to be taken. Landlords can continue to demand rent, and they can deal with consents without waiving their right to forfeiture. But however, the same forfeiture. Forfeiture is still exercisable for other breaches, and obviously the forfeiture requirements for waiving the breach remain for those. There's a similar moratorium in relation to statutory demands and winding up petitions. Those there is a moratorium on them until 31st of December 2021 or 31st of March 2021. And there's also an additional number of days required in order to exercise commercial rent arrears recovery, CRAR, and that is now 366 days, and that has been the case since December 2020. I think the most important thing to note about the commercial landlord situation is that essentially nothing can really be done until the 31st of March 2021. So I think everyone needs to just draw a line in the sand until then. And as I'm sure all commercial landlords are aware, the government has published a code of conduct and for landlords and tenants, and it's been endorsed by various organisations, including RICS. And basically the code encourages a principle of collaboration and transparency, and encourages landlords and tenants to act reasonably and responsibly. And I hope that that's what we continue to do. With regards to residential tenancies, the part of the Coronavirus Act 2020 that applies is Section 81, and that essentially extends the notice period for the service of Section 8 and Section 21 notices. Previously, Section 8 notices had a 14-day notice period, and now it's 6 months. And Section 21 notices had a 2-month notice period, and now it's 6 months. So it applies to all residential tenancies. So there's essentially a moratorium on, well, I mean, not exactly a moratorium, but essentially it makes it more difficult for landlords to exercise the right to possession. And in addition, there's a moratorium on evictions in England and Wales until after the 21st of February 2021, unless there are some exceptional circumstances, i.e. antisocial behaviour or excessive rent arrears. So again, landlords' hands are tied in terms of residential tenancies also. It should be noted that there was an automatic stay of possession proceedings placed pursuant to CPR 51Z in March 2020, and that continued until September 2020. But since the 29th of September 2020, landlords have been able to issue possession proceedings again. However, any proceedings that had been issued prior to the 3rd of August 2020 require a reactivation notice, and that reactivation notice needs to be filed at least 42 days prior to any hearing. And it should also be noted that these possession these notices of reactivation also need to be filed before the 29th of January 2021. Otherwise, an application to the court will be necessary to remove the stay. I just wanted to bring your attention to the Public Health Coronavirus Protection from Eviction England Regulations 2021. That basically updated the 2020 regulations. These were brought into force on the 11th of January, And as I advised previously, the main changes are that the prohibition on landlords enforcing most warrants and writs of possession, except in limited circumstances, are extended to 21 February 2021. They were previously 11th of January. And now the level of arrears that need to have accrued in order to allow a landlord to rely on the excessive rent conditions is now 6 months as opposed to 9 months previously. And those rent arrears can have accrued from either before or after March 2020. There is also just something I thought of note today. There is a new regulation, the Debt Respite Scheme, Breathing Space Moratorium and Mental Health Crisis Moratorium in England and Wales, and that's coming into force on the 4th of May 2021. This will allow a debtor to seek a debt moratorium essentially from an approved debt advice provider. And obviously not everyone will be able to obtain this because obviously they'll have to show that they'll be able to pay their debts after being given a breathing space essentially. However, it is something for landlords to be aware of if they're considering issuing notices shortly after the 31st of March, that they need to move swiftly in case their tenant might perhaps try to obtain a debt moratorium after that date. It should be noted that a Section 21 notice can still be served even if someone has a debt moratorium in place, but obviously Section 8 notices for the grounds for rent arrears recovery won't apply. I'd like to end by once again emphasising what the government has said in relation to debt collection and possession orders during this time. And the Ministry of Housing, Communities and Local Government has stated in their technical guidance on eviction notices that, and I quote, "We strongly advise landlords not to commence or continue possession proceedings during this challenging time without a very good reason to do so. It is essential that we work together during these unprecedented times to keep each other safe." Thank you for listening, and apologies for my lateness.
Thank you very much, Eileen. I suspect that once the regulations are lifted, there's going to be a flood of proceedings being commenced, because certainly I know from sort of landlord clients who obviously are holding back, have sort of done deals and tenants are not keeping to the deals. And I can just see that there's going to be a real flood of emails coming into your inbox about this.
Hopefully.
Okay, ladies and gentlemen, we've had some pre-submitted questions, so I'm going to pop these to you. Whoever wants to answer, please jump in and do so. Someone's saying here that we recently served a break notice on their behalf, and they're leaving their premises in early March. They're in negotiations on dilapidations, and they're also looking for premises, seriously thinking about going into serviced offices. What are the key points to look out for?
Maybe I could just start on that and then Eileen can come in. The break notice, most break notices do, and I have to say, this is an inquiry I'm getting from a lot of clients, because those of you who were listening to some of the panels that I was involved in last year will have heard that I had become less of a transactional lawyer, more of an advisory lawyer. And at one point we were serving break notices as if there was no tomorrow. The first thing is to make sure that all the provisions of the lease are complied with. So if the lease says all rent is to be paid up to the date of termination, then that is exactly what it means. So if you are wanting to do a deal with the landlords, don't be sly, just say to the landlords, look, we are leaving. Part of the reason we're leaving, we can't afford to pay all the rent. Some landlords, and I've had a client who's done this, has said, okay, make a proposal and then pay what you can now, and let's see how it goes. But that's not always the case. If you've got a bona fide dispute on service charges, there you might be on something a little stronger, particularly if you've got a paper trail, because very often, particularly some of the older leases, only talk about rent in the singular being paid before completion. A lot of leases define rent service charge and insurance as rents, plural. And whilst this may be a technicality, of course, it does mean that service charge and insurance premium is then included. So that's something worth looking out for. But if you are in a genuine service charge dispute, please do keep a paper trail. So we're then on dilapidations, and you will probably get a visit, if you haven't already done so, from the landlord surveyor. We had a client last week who was about to move out last Thursday, and 2 days before, the landlord surveyor said, oh yeah, we want all these glass partitionings moving, which, it was a bit of a midnight demolition job. Try and find out what the landlords want. Most landlords will come up with a schedule, X £1,000, get a surveyor in, negotiate it, because the landlords always ask for more, and that there is their room for negotiation. And do find out what the landlord wants. There is then the definition, which is normally in a lease that's required, vacant possession at completion. But the definition of vacant possession, I'm sure, is something that Eileen will talk us in a couple of minutes. So you then say you're thinking about going into serviced offices. Serviced offices has become a huge growth area. I have dealt with serviced offices in my time, both acting for client, a major service office provider, and also having had in my previous firm 4 years in serviced offices. I like the concept of serviced offices. It's a very good halfway house. And at the moment, serviced offices are becoming very popular because clients don't want tenant clients don't want long-term commitment. And most serviced offices will do a license for 6 months or a year. The key to remember is that you are a licensee, you are paying a license fee, usually monthly, often ask for a license fee deposit, which is the same as a rent deposit, and you will get a license. You need to closely check what is being provided. Most good licensors, the people who own these buildings, provide many services, including a lot of them have social areas where you can actually meet other people who are in the building. And as my client Giles Fuchs, who's the chief exec of a well-known London office space company, Office Space in Town, said in an article in City AM, the belief that we want to be in an office is underpinned by our social nature as human beings, the craving to be part of a collaborative community on which part of the appeal of the office rests. I wrote a column in the London Chamber of Commerce magazine a couple of months ago saying that one of the things that was concerning me was that particularly our younger members of staff were not interacting with some of our older members of staff, because you learn an awful lot by chatting to people in the kitchen, round the water cooler, or just sitting listening to your principal making a phone call. But the serviced office business that is certainly growing. I've been looking at quite a few figures, various trends and various reports, and the conclusion generally is that the serviced office market is a growing market. You've got different kinds. There's the WeWork model, which possibly suits the new business or the younger business more. And then you've got the more established serviced offices, which tends to suit more the growing but more mature business. But like with a lease, the key is negotiate, read the documentation. You then will find that you have the right to use an office, to use the common spaces and many of the facilities for a one-off fee. And I think it's a good concept and something that I have recommended to clients in the past. But, you know, like with everything, there are always pitfalls. So read the documentation or pass it to your lawyer to read. And then I think Eileen could tell us a little bit more about how to behave when you're leaving premises.
Thank you, Michael. Well, obviously, as Michael touched on, in order to operate the break clause, the tenant needs to ensure that all rent is paid up to date, and that includes interest, and that all covenants in the lease have been performed, and that there's no material breach of the repairing covenants. And probably most important of all, I think, vacant possession, and whatever that may mean. But currently, I mean, usually vacant possession means no people on the property, the removal of all chattels, and the landlord is given immediate and exclusive control of the premises. There has been some recent case law on this, which I think probably a lot of people might have read about, and I understand it will be appealed. However, it's Capital Park Leeds versus Global Radio Services, and unfortunately, in that case, the vacant position given was a bit too vacant. So they apparently took lots of things they shouldn't have, and the landlord essentially received the property in what the judge classed as a dysfunctional condition. So obviously that definitely, it impinged upon his enjoyment of his property. So it was found that vacant possession hadn't been given, so that the operation of the break clause actually hadn't properly occurred. So that's something to be aware of. It's really difficult, because obviously before that there was the Riverside case in 2016, where essentially it was held that vacant possession hadn't been given because there was still partitioning in place. So it's almost like you're damned if you do, you're damned if you don't. And hopefully when Capital Park Leeds is appealed, we'll get a little bit more guidance on what vacant possession actually means. But at the moment it is quite difficult. But obviously, as Michael touched on, the most important thing is to make sure all your rent's paid up to date, and that you give vacant possession as much as possible. My top tip for anyone, signing up to commercial lease tomorrow, or the next day, carry out a schedule of condition, take lots of photos, make sure that you know exactly what the property looks like. If there are any licenses for alterations entered into, keep them in a very safe place so you don't lose them, because these things do tend to walk, and it's really important that you know, A, what the property looked like when you moved in, so that B, you can give it back in that exact condition when you leave. Thank you.
Okay, sage advice there from Eileen. Another question we've got coming is someone saying their block had an external wall inspection. Abu, I think this might be for you, but works have been recommended and we've yet to receive the all clear. Can I sell or refinance?
So they need to have a look at what the recommendations were. So it would be contacting the managing agents and asking for a copy of the report. And if works have been scheduled, they'll most likely maybe already received a notification that there's pending works, and in terms of estimates for the cost as well. So they should make contact with their managing agents and see where they stand. If it is simple works and they are scheduled to take place in a relative period, usually it does take some time for you to find a buyer. So it's something that could be possible for them. And also, say even if the works haven't taken place, but at least there's a quote, during the conveyancing process, we could just add in a retention or something. So that way the buyer can go ahead, and it just depends really on what's in that report. So it's something worth looking into, and yeah, they could potentially be able to sell in the next coming months.
Okay, Abu, how flexible are lenders on the requirements of an EWS1 certificate?
So initially, surveyors were going out on valuations, and there's been quite a lot of stories of them valuing a property without a certificate at a value of 0. More recently, as there's been further guidance from the government since December, I think the values that are going out, they'll just kind of mention in the certificate and point to the conveyancers that they've got to look in and check on what the position is. And then most solicitors that are acting will kind of refer back as there may not be a certificate, but there is a fire risk assessment. So then you'll end up going back to an underwriter to kind of consider. So some lenders may be flexible, but it really is on a balance of how things are. It varies between lenders. Interestingly, there are those not traditional lenders as well that certain people could look into, because you've got like crowdfunding for property as well, and also there's quite a few new lenders that have come into the market, as well as I think in terms of Shapiro finance and so forth. So those guys look at things certainly different to Santander and Barclays and those main lenders, which they could look into as well.
Right, so it's being careful in your selection of lender, is what you're saying.
Yeah.
Yeah. Okay. Someone else is saying they own a maisonette and they rent the property through a letting agent to an agency who rent out the rooms individually. There was a 3-year term that expired in November last year, 2020, and negotiations regarding the rent for a further term have proved futile. The owner would like to regain possession of the property ASAP. What steps can we recommend in light of the COVID Act 2020? Sounds like one for you, Eileen.
Oh, exciting time. I'm going to be honest, it really depends on the type of agreement. I have seen these type of agreements obviously as just a letting agreement, which is obviously standard, and it gives a 3-month notice clause, which is quite simple. But I've also seen these kind of agreements drafted as a common law tenancy, which makes it a little bit more complicated, because the Protection from Eviction Act 1977 will apply, and that provides that essentially you can't regain possession of your property without an order from the court. So given however that the term has actually expired, I mean, he could simply write to the letting agent, and if it was a common law tenancy, and just advise that obviously that he requires vacant possession, or he or she, sorry to be sexist, requires vacant possession immediately. And obviously if that doesn't happen, then obviously a notice of quit could also be served simply for belt and braces if the letting agent is particularly slippery, I suppose. Obviously, the difficulty is though that you will still require a possession order if the letter and the notice to quit don't work, and that will take quite some time. And obviously, there's the moratorium on evictions until the 21st of February. I'm sure there's a massive waiting list in the courts for possession orders. And so I think there might be some difficulty unless there's a lot of goodwill on the letting agents and the letting agents' tenants' part. Similarly, if it's a letting agreement notice, even if you serve the notice correctly on them, say it's a 3-month standard notice, you would still have to be aware that you probably won't be able to do anything before the 21st of February. At the earliest, probably the 8th of March, and 2021. And realistically, again, you will be relying on the goodwill of the landlord and at the letting agency and its tenants, because there's not much to be done to quicken up the court process essentially. So it's kind of a how long is a piece of string question.
Okay, so string comes into it. Fair enough. Okay, I know, Abu, that you typed an answer directly back to the person that asked that question, but not everyone could see that. We were asked a question earlier. Do you anticipate any changes to the EWS1 process to assist with the current problems? Clearly, a simple solution is not available, but it does seem the current process is, in some cases at least, part of the problem rather than part of the solution. And you're going back and saying that obviously I should like to reiterate the answer so that everyone can share in that one.
So at the moment, it doesn't seem likely that the government will be issuing any further changes, and that was just more sort of clarification, because there was issues taking place in the market. And yes, I partly agree that I do see the need for the certificate, but due to the fact that there's lack of experts and also those that are able to work in the area, that's kind of causing this problem and leaving flat owners and so forth being left in this situation where they're incurring costs, unable to live in properties that they're wishing to come out from, or having to rent them out, and they have to think of alternatives than actually being able to just sell them and move on. So I think the only kind of thing that I kind of see happening this year would be that there's going to be changes with regards to regs, and in terms of managing agents, kind of thinking of more ways to help manage and to be able to survey the properties that are left, and also kind of change the way that they have the waiting watches and so forth, to minimise the cost, because it is sometimes they're paying nearly £30 an hour to someone to do a waiting watch outside these buildings. So there is quite a lot of costs being passed on to the leaseholders.
Okay. Right, that seems to be the questions for today. So thank you, the three of you. It's been a really interesting and useful exercise this afternoon with dilapidations, break notices, and EWS1 forms being the hot topics. I know that all of you are writing articles on all of this in the next couple of weeks anyway, so everyone can watch out on the website and on LinkedIn as we fly all of those round. We are also back in 2 months' time for an update on property. Next month will be the construction version of today's talk. And as always, if you have any questions for any of our panelists today, please do not hesitate to email them. I know sometimes it's awkward to ask a question in an open forum. If you have a specific query, you can get Michael on michaelshapiro@silverllp.com. Abu can be got via abu@silverllp.com, and Eileen, obviously, eileen@silverllp.com. And the guys will be happy to have a chat with you, or give you some advice, initial advice on whatever your query may be. So it just remains for me to say thank you very much to our panelists for sparing the time to come and talk to us this afternoon. We look forward to seeing you all again soon. Thank you, guys, and everyone that's logged on this afternoon. Thank you for attending. See you all again soon. Take care.
Thanks. Bye, everyone. Take care.
Bye.
Bye.